In the important case of Street and Mountford, Street and Mountford entered into an agreement which gave Mountford exclusive possession to 2 rooms in Street's house. The agreement itself said that it was a license. Street then attempted to terminate the agreement and to kick Mountford out by giving Mountford only 14 days of notice. Now, Street would have been entitled to do so if the agreement was actually a license as it states on the agreement itself. But if the agreement was a lease, then the lease would have come under the statutory regime of the Rents Acts, and so Street as a landlord cannot simply kick Mountford out with giving such short notice. The House of Lords held that notwithstanding what it says on the agreement was a lease and not a license. Lord Templeman, in a off-cited speech, gave the requirements for what a lease is. He says, "There can be no tenancy unless the occupier enjoys exclusive possession. But an occupier who enjoys exclusive possession is not necessarily a tenant." So here he's recognizing that there must be some other elements. He says, to constitute a tenancy, the occupier must be granted exclusive possession for a fixed or periodic term contained in consideration of a premium or periodical payments, the latter referring to rent. The grant may be expressed or it may be inferred where the owner accepts weekly or other periodical payments from the occupier. He goes on to state that what matters is not that the parties intended to create a lease. The only intention which is relevant is the intention to grant exclusive possession for a term at a rent. Whereas in the present case, the only circumstances are that residential accommodation is offered and accepted with exclusive possession for a term at a rent. The result is a tenancy. Finally, he gave a warning stating that the courts should, in my opinion, be astute to detect and frustrate sham devices and artificial transaction whose only objective is to disguise the grant of a tenancy and to evade the Rents Act's application.